And here are the crypto top headlines covered in this video. Judge in SEC versus Binance case will hear arguments on whether crypto is a security. Next, court decisions could rein in SEC authority over crypto industry. Also, Grayscale CEO's warning, only 2 or 3 spot Bitcoin ETFs are here to stay. Welcome to Crypto Top Headlines, where there's no clickbait thumbnails or titles, and no speeches on my opinions, just bringing crypto's news to you. We are a new channel here on YouTube, and would greatly appreciate it if you would click on the like and subscribe buttons, as well as the notification bell. It does help support the channel, so thank you in advance for doing so. Now, on to these headlines. Our first top headline, Judge in SEC versus Binance case will hear arguments on whether crypto is a security. Binance.US's legal team will be allowed to address whether a digital asset remains a security in perpetuity and staking as a security in court. Federal Judge Amy Berman Jackson, overseeing the United States Securities and Exchange Commission case against Binance, Binance.US, and former CEO Changpeng Zhao, has ordered a court review of whether digital assets are securities. In a minute order dated January 18th in the U.S. District Court for the District of Columbia, Judge Jackson said she would hear arguments on how the SEC treated cryptocurrencies under current regulatory and legal frameworks. Lawyers representing Binance.US will be allowed to address whether a digital asset remains a security in perpetuity and the SEC's allegations that staking may be considered a security. The court intends to hear arguments on whether an investment contract must involve a contractual undertaking and whether the SEC misunderstands the meaning of scheme in Howey from one defense attorney only, said Judge Jackson. Similarly, although both memoranda address the major questions doctrine and both raise background questions about whether litigation is the appropriate way for the SEC to proceed to oversee the crypto industry at all, one attorney should be assigned to argue that issue for the defense. The Howey test has been the SEC's standard for determining what is a security is by ruling whether an asset meets the definition of an investment contract. Judge Jackson raised the issue, assuming it would need to be addressed in Binance's case over tokens including BNB and Binance USD. It's unclear whether both sides will present arguments on the matter. In many of its legal actions against U.S. crypto firms, the SEC has claimed that tokens largely qualify as securities and are subject to regulatory oversight by the Commission instead of the Commodity Futures Trading Commission. In July 2023, a judge overseeing the SEC's case against Ripple ruled the XRP token was not a security regarding programmatic sales on digital asset exchanges. Since the Ripple ruling, lawyers for Coinbase, also facing a lawsuit brought by the SEC, cited precedent from the case in an August 2023 motion to dismiss. In other cases, the SEC has pushed back, arguing in its lawsuit against Terraform Labs and Do Kwon that whether certain tokens were securities was a legal question for a court, not a factual question for the jury. Let me pause here for a moment. If you're getting value out of this video, please click on the like and subscribe buttons as well as the notification bell. Our next top headline, court decisions could rein in SEC authority over crypto industry. The SEC wants some tokens offered by crypto exchange Coinbase classified as securities, making it easier to regulate the industry. Federal Southern District of New York Judge Catherine Polk heard arguments during a 5-hour hearing Wednesday afternoon in a case that could decide the regulatory future of the $1.7 trillion cryptocurrency industry. Lawyers for the U.S. largest crypto exchange Coinbase argued that the courts should dismiss an SEC lawsuit alleging that the exchange violated securities laws by operating as an unregistered broker-dealer in buying and selling similarly unregistered digital assets. Wall Street's top cop, the SEC, asked FELA to rule against Coinbase's motion to dismiss because the company, in the agency's view, clearly flouted securities laws and that discovery for a future trial should begin immediately. Legal experts say it could take FELA anywhere from 2 to 6 weeks to make a decision. If and when the case advances, the outcome could mark an important precedent in U.S. crypto regulation. If the court sides with Coinbase, it could significantly hamper SEC Chair Gary Gensler's attempt to regulate the crypto business through various enforcement actions. Since becoming chairman, Gensler has brought more than 50 crypto enforcement actions for various rule violations. An SEC victory over Coinbase would allow Gensler to continue pursuing that agenda. The lawsuit alleges that Coinbase is operating as an unregistered broker, exchange, and clearing agency by offering 13 tokens the SEC believes to be securities, and thus in need of registration with the agency, just like a stock or bond. Coinbase argues that no token sold on its platform constitutes securities because there's no underlying investment contract between the token issuers and users who are buying the tokens on the secondary market. Gensler has said repeatedly during his tenure at the SEC that most digital assets aside from Bitcoin and possibly Ethereum constitute securities under the 1946 Howey test, a Supreme Court decision that determines whether certain transactions qualify as investment contracts. If they do, they have to get registered with the Commission, a move crypto companies have resisted given the industry's desire to remain outside of government control. The crypto industry, for its part, says the current SEC registration process doesn't cater to the nuances of blockchain technology, and it's therefore impossible for them to simply come in and register their products. It believes many token offerings don't meet the Howey test requirements because there's no underlying contract between issuers and buyers, a key requirement for satisfying the test. It also thinks the SEC is acting outside its mandate and that Congress should give jurisdiction to the Commodity Futures Trading Commission, known for a slightly lighter touch when it comes to regulation. FELA has echoed the industry's concerns that the SEC is broadening its horizons too much when it comes to crypto. I am concerned that what you're asking for is too broad a definition of what constitutes a security, FELA said during Wednesday's hearing. I care about how the law develops in this case before me, and I care what it means going forward. The debate in the Coinbase case is being played out both in Congress and in other legal cases. In July, the crypto industry was handed a partial victory when U.S. Southern District Judge Torres ruled that the token XRP was not sold as an illegal security when it was traded between retail investors on exchanges. She also ruled that it was a security when it was sold by cross-border payments company Ripple Labs to institutional investors to finance the development of its platform. Torres's decision was made clear that digital assets are not themselves securities, but the way in which they are transacted could make them subject to SEC oversight. The SEC has said it intends to appeal the Ripple decision. In August, another Southern District Judge, Jed Radkoff, known as the Dean of Securities Jurists, sided with the SEC and ruled that Terraform Labs, Luna, and MIR tokens were indeed unregistered securities. Both Radkoff's and Torres's decisions were brought up frequently during the Coinbase hearing, with the SEC relying on Radkoff's ruling to support its argument, while Coinbase lawyers used Torres's decision regarding secondary market sales to support theirs. Arguments from Coinbase, Ripple, and others that digital assets don't fit into the parameters of the Howey test have called into question whether securities laws written 80 years ago that were designed for the regulation of Citrus Grove investments are still practical when it comes to regulating modern technology such as blockchain and artificial intelligence. Congress is keeping track of the regulatory debate. GOP Senator Cynthia Lummis from Wyoming asked FALA to dismiss the Coinbase suit because such enforcement actions will hamper the development of the underlying technology of crypto, known as the blockchain, which has transformational potential in reducing costs of various transactions. In an amicus brief in support of Coinbase, Lummis criticized the SEC for overstepping its authority. The SEC's attempt to shoehorn an entire new class of assets into the existing definition of a security and thereby add to the definition enumerated by Congress exceeds the SEC's authority, encroaches on Congress's lawmaking, and contravenes the separation of powers, Lummis wrote. Lummis has been a vocal advocate of crypto, introducing legislation in the Senate that would help bring regulatory clarity to the industry. In the House, a handful of lawmakers, including Chairman of the Financial Services Committee, Patrick McHenry, have also been championing crypto with bills that will establish so-called regulatory rules of the road. Coinbase is not the only case that could have a significant impact on the SEC's ability to regulate crypto. The Supreme Court is currently hearing arguments for the overturning of a 1984 precedent that says courts should defer to an agency's reasonable interpretation of an ambiguous statute. SCOTUS's conservative justices are expected to rule in favor of overturning what's come to be known as the Chevron doctrine. Doing so would significantly scale back the regulatory power of federal agencies like the SEC and could further restrict Gensler wielding power over the crypto industry. Our next top headline, Grayscale CEO's warning. Only 2 or 3 spot Bitcoin ETFs are here to stay. The spot Bitcoin ETF fee war will not save the funds from being eventually pulled from the market, the Grayscale CEO believes. Most of the spot Bitcoin exchange-traded funds approved by the United States Securities and Exchange Commission won't survive, Grayscale Investment CEO Michael Sonnenschein says. In a January 18th interview with CNBC at the World Economic Forum in Davos, Switzerland, Sonnenschein predicted that the majority of the 11 approved spot Bitcoin ETFs will likely fail. The U.S. SEC officially approved 11 spot Bitcoin ETFs on January 10th, with 10 beginning trading the next day. Many ETF issuers were actively lowering their trading fees to raise competitiveness with other ETF sponsors, with most of the approved ETFs setting fees between 0.2% and 0.4%. Multiple spot Bitcoin ETF providers also offered temporary fee waivers. On the other hand, Grayscale, the largest Bitcoin holder among Bitcoin ETF issuers, charges as much as 1.5% without any waivers. Sonnenschein defended Grayscale's fees for its spot Bitcoin ETF product, which are the highest in the market, stating that only 2 or 3 spot Bitcoin ETFs are here to stay, and the rest will be pulled from the market. I think from our standpoint, it may at times call into question their long-term commitment to the asset class. I don't ultimately think that the marketplace will have ultimately these 11 spot products we find ourselves having. Sonnenschein's remarks came on the 5th day of spot Bitcoin ETF trading in the United States. Since the trading launch, Grayscale has become the only issuer aggressively dumping Bitcoin, offloading as much as 37,947 BTC by January 18th. In contrast, the other 9 issuers have added at least 40,000 BTC to their products since the start of trading. Quantum Economics founder Matti Greenspan doesn't rule out the possibility that most ETF issuers will likely fail in the long term because most investors will prefer to hold their assets or opt for self-custody. For now, having spot ETFs is a good way for some portfolio managers to gain exposure who wouldn't otherwise be able to, Greenspan told Cointelegraph, adding, but 11 of them is pretty ridiculous. There will have to be a consolidation, and they all know it, which is why fees are on the floor. Some executives at spot Bitcoin ETF issuers believe there's no conflict between self-custody and spot Bitcoin ETFs. Self-custody and an ETF are not mutually exclusive. ARK Invest CEO Cathie Wood said during a space on X on January 10th. She also noted that ARK's Bitcoin ETF, which charges a fee of 0.21%, doesn't aim to maximize profits. We are looking at Bitcoin as a public good, and one of the ways to do that is this low-fee product. We have other actively managed strategies where we can do more on the profitability side. That is not our objective here, Wood stated. So this concludes our top headlines. If you haven't already done so, don't forget to click on the like and subscribe buttons, as well as the notification bell. Also, leave your thoughts in the comments and share this video with your friends and family. Thank you all for watching Crypto Top Headlines, bringing crypto's news to you.